Jason Smith?
Sir.
Okay. You're here with Mr. Kindler, your attorney and the state's attorney. There are two motions to revoke probation in cause number 18-28788 and 18-29417. And to round out the field, we have a new indictment, which is the problem here. You were placed on probation earlier, and then now we jumped up with something that should have never happened. You're alleged to have committed the first-degree felony of aggravated robbery, which carries with it up to life in prison. What a mistake. And you're looking at a second-degree felony in 29417, up to 20 years in prison for that, aggravated assault with a deadly weapon, and a second-degree felony for illegal possession of a controlled substance, which, let's see, what is it? Methamphetamine. The hits keep on coming here. Okay, what are we going to do?
No further statement.
Got it. All right. Judge, I have sent you a dismissal on the new charge.
This one, 25 CR 1015.
Yes, sir.
I don't have it.
Oh,
Yeah.
it's on.
That was,
Okay.
and the reason why you haven't received it yet is it's on yesterday's.
Yes.
Then what?
I just asked them to.
Yeah.
What are we going to do on these two motions?
The agreement with the defense is he's pleading true to count two on the two motions.
Yeah, the community service obligation.
And then what?
And we are not in agreement as to the disposition. So we'll leave it. It comes to you. Yes, sir.
The first thing is, notwithstanding all of this,
Yes, sir.
this 25 CR 1015 motion to dismiss, all the parties want me to sign it now, correct?
Correct,
We
Judge.
don't need to wait.
No, sir.
No, that.
This dismiss.
Thank you, Your Honor.
In the interest of justice is what it says.
Correct.
Just call me. Anybody has thoughts on that?
Two cases, 18-28788 and 18-29417, the state of Texas versus Jason L. Smith. That is you, sir.
Yes, sir.
And with Mr. Kindler, your attorney, and the state's attorney. And probation is here, of course. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
So wait.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Put your hand down. In summary, 28788 states, in summary, that on or about June 21st, 2019, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison, and that was suspended, and you were probated for 10 years for the second-degree felony of illegal possession of a controlled substance. And as we know, it is methamphetamine here as listed in this indictment. Is all of that true and correct?
Yes.
I'm writing, I noted that in each of these cases, the defendant pleaded true to allegations 2 and 3 back on August of last year. And
That's
then
correct, Judge.
we did not move forward on that for whatever reason.
If the defendant, the federal government filed a case on him at that time and was put into federal custody recently, so
So what are we doing on these two?
we would proceed with
Same thing, Judge.
plead true
Okay.
proceedings.
In each of these two cases, sir, allegation 2 states, and we can take these up together,
Okay.
that you failed to, in number 2 states, you failed to provide verification of performing community service as required in violation of condition 17 of your probation order, which states being, hello? Sandy.
Where'd you go?
What?
All right. This, we got another file. It's misstated on the condition. It says in condition, you failed to perform community service hours in each of these in violation of condition 17 of your probation order. 17 of your order says be inside your home every day from 10 to 6. It's curfew. It has nothing to do with this. Number 15 does say in your community service supervision orders, perform 800 hours of community service restitution. So that's what that is. So that's a mistake. Well, should be changed to 15. Any objection? Condition 15. All right. Once again, in each of these two allegations of these motions to revoke probation, allegation 2 states you failed to provide verification of performing community service hours as required and directed in violation of condition 15 of your probation order. Is all of that true and correct? Are you pleading true and correct to that voluntarily and because it is true as it is alleged?
Yes, sir.
You understand that a voluntarily and knowingly made plea of true to one or more violations, that's of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked in these two cases. And in 28788, you can be sentenced to no less than 2 nor more than 10 years confinement in prison because you were on regular probation for 10 years confinement, suspended for 10 years. And in 29417, your probation could be revoked. You could now be found guilty because you were placed on deferred or unadjudicated probation in that case. And you could be found guilty and sentenced to the full range of punishment of no less than 2 nor more than 20 years confinement in prison. That's a total of 30 years in prison, but collectively. Do you understand what can happen and the consequences that can occur by your pleas of guilty or true to these violations of probation?
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
There's one other violation that was earlier pleaded to, and that was number 3. You failed to pay court-assessed fees as directed, and you were in arrears $564 in one case and $1,334 in another case, and that's for your probation fees, costs, etc. Were you able to pay those?
Not at the time. I actually run my own business, so I didn't have a lot of work at the time.
So you weren't able to pay those?
No, sir.
What was the date, Your Honor, of the hearing?
July 3rd of last year. So at that time,
No, sir.
okay. That's about $2,000
Correct.
total. But you had your own business
Yes, sir.
and you couldn't pay that?
No, sir. I didn't have a lot of work coming in at the time,
What was your business?
like construction. I didn't have any clients or any work going on at that time to bring anyone in at the time.
In this town? You couldn't find a construction job?
Yeah,
Okay. Were you trying hard,
absolutely. I'm on Facebook,
sir?
Google. I'm on Facebook and Google. I make posts all the time and I drive around and just look for properties.
All right, what are we gonna do? What, do we have an agreement on anything?
There's okay.
No agreement. What do y'all, okay.
I would just observe that since he's been in custody since, I believe, June 28th of 2025, that he's developed, I would say, with cancer.
It actually, they removed it. So I'm in remission from it, I believe is what they consider it.
They have procedures while he was in custody in Houston to remove lymph nodes.
Yeah, my lymph nodes in my growing area. I'm waiting on an MRI for the black spot on my liver, but
Okay, what does that have to do with
Well, just
the commission of these offenses?
Nothing, Your Honor, just it may be relevant to the court's decision in revocation.
The sympathy move.
Well, the state would have to pay for its next material. Something that may be considered out of the court's cognizance.
Well, of course, if that was it, people would start cutting off their fingers so they don't have to go to jail. I mean, that's, we all have physical issues.
No, it's a rather mercenary.
Yeah, it's a Hail Mary throw. But sometimes those things are caught in the end zone, you know? Your misdemeanor history, you've got a Class C theft conviction back in 2014 of evading detention, 90 days in jail, and 14 Class B theft, a second Class B theft, 90 days jail. And 14 reckless driving. That was deferred and it expired. Okay, that looks like it. Correct, sir?
yes,
How much time does he have? Please, go ahead. On. Okay, the facts on the pre-sentence report, and then I'm going to let the lawyers sentence on clause number 28788, which is this illegal possession of a controlled substance on or about June 15th, 2017. The police stopped your vehicle as there was information they had that you may be transporting narcotics in a silver Dodge Ram truck. Yeah, that was your truck, I guess. And they smelled the odor of marijuana. You consented to a search. As a result, a plastic baggie with methamphetamine was found in the center console, and then you pleaded guilty to that. But on this 29417, aggravated assault with a deadly weapon, this occurred subsequent to this June 15th incident here, as on October 28th of 2017. 17. Should have been July, August, September, 4 months. At 10:30 p.m., let's see. People were in the vehicle with an 18-month child, old child, on Nederland Avenue when apparently you pulled up next to their vehicle for whatever reason, pulled out a small caliber handgun with a laser attachment and stated, "I ought to shoot your bitch ass," and then sped off. After dropping the children at a babysitter, the complainant and the other person headed to Beaumont, and then you came up from behind, drove around getting in front of their vehicle, attempted to stop in front of them, and there was a little chase going on at speeds of over 100 miles an hour on Interstate 10. Police were contacted by phone by the complainants. And let's see. And they were told to meet officers at Parkdale. Apparently, the next day, the incident was reported to Nederland Police Department, and they made contact with you, and then apparently that meeting with the police never occurred. Then the district attorney's office indicted you for aggravated assault with a deadly weapon. And so that's indictment states you knowingly and intentionally threatened the complainant by stating, "I ought to shoot your bitch ass," and then did in there use a deadly weapon, namely a firearm, during the commission of the assault. You pleaded guilty to that. And then you were placed on deferred probation on that case and regular probation on this earlier one, the illegal possession of controlled substance. Okay. Go ahead, Steve. I think I see where we are.
All right, so Judge, I believe the disposition originally on these cases predates me having this caseload. I can tell from the PSI that there was a state jail felony offense originally. Possession of controlled substance. When you look at that PSI there that stated, it appears that in April of 2018, we dealt with the state jail and the possession charge, and what Your Honor did was order that he do some state jail time and then successfully complete the substance abuse felony punishment. He picks up the aggravated assault charge on October 22nd, 2018. He's granted deferred as all those are operating. And then in 2019, the possession charge is changed over to a straight probation. So that's really the only kind of the procedural changes that occurred there. And I point that out because I believe we've used a lot of resources to try to get his attention, and hopefully he would successfully complete probation. Based upon the pleas are true today, we know that he's failed in that regard. The offenses themselves warrant a prison sentence, specifically the aggravated assault.
He's got, by the way, 602 days credited. Almost 2 years.
Because one of the offenses has a 10-year probated for 10 years, I'm suggesting to the court that he be sentenced to both cases for a term of 8 years to run concurrent.
Oh, go ahead, Mr. Campbell, on behalf of the defendant.
Yes, Your Honor. I think that, again, I don't want to speak out of turn or put words in the state's mouth, but for the new offense that was alleged and then abandoned and dismissed, that perhaps we wouldn't have an MTRP before the court just for community service and administrative violations, which is where we are at this stage. I would agree that if the state had been able to prove up the new aggravated assault, or if the federal government had chosen not to dismiss that case, then this would be in a different posture before the court for revocation. But as it stands now procedurally, what the court has before is a violation for community service and non-payment of fees, maybe $2,000 a year. So I would just argue that given those circumstances, that revocation at this point would be disproportionate to the violations that have been proved up.
On the aggravated robbery that was alleged,
Yes, sir.
What happened on it? That was dismissed, or y'all
The
decided?
whole reason why I'm forced to dismiss that is my complaining witness has relocated to Georgia.
Okay. All right.
I talked to
You don't have a
him.
complaining witness available.
I talked to him at the time in which he originally entered this plea in August. He was cooperative then. The state had more than sufficient evidence. I suggested to defense counsel that it would not be a wise decision to move forward with his request for a motion to revoke probation because it would have resulted in points on both of these offenses and the sentencing guidelines calculations. He followed my advice and we reset this matter. And had I proved that up, I would have been requesting a minimum, I would have been requesting 20 years on the aggravated assault. So I've taken that into consideration in the request I put before the trial.
With respect to Mr. Hand, Your Honor, the factual predicate of the aggravated robbery served as the factual basis of the indictment in federal for carjacking. I believe another offense. That case was set for trial. We were prepared to try the case. After a pretrial conference with Judge Crone, the federal government chose to dismiss that case based upon,
Okay.
for whatever reason, I would assume some sort of evaluation of the facts that were more in line with an actual proving the case up. But I would just say that the same factual predicate that the state is asserting on the aggravated robbery was looked at independently by the federal prosecutor and was evaluated in such a manner that precipitated or necessitated dismissal of the case pending trial.
Okay. From probation, I want to ask you on this failing to provide verification of performing community service hours as required. Can you give me a hint? What has he done, if anything? On
That's
that?
community service.
Yes, ma'am.
He hasn't done any.
None. None. And he was on probation since 2019
2018, I believe.
in one case and 2018 in the aggravated assault case. And we're talking about a period of time through or what, 6, 7 years?
Yeah.
Nothing.
Well, he has been incarcerated
How much of that time has he been incarcerated?
since June 28th
It would have been 3. I done 2 years in state jail while the probation.
How much time were you free man in this period of time from June 21st, 2009, October 22nd, 2018 to today, which is almost 8 years?
5.
Sir?
Five.
So there were 3 years then that you were out and about and you didn't do one dime of
No.
community service. Okay. Anything else?
Right, if you wanted to, anything that you wanted.
You have a chance to speak if you wish. Go
It's
ahead.
just during that time I was working and actually trying to start my business and I had a family going and things like that. It's just, I didn't have a whole lot of time for that part. I was taking the classes. I've done every class. I've even done the drug program for them. The only reason why I was behind my fees now is because I didn't have work. But any other time in the past, I've gotten behind my fees from not having work. And every time I've gotten a new job, I paid in full.
How much, since he's been on probation, how much has he been credited for payment on fees, costs, et cetera?
His assessed fees were 10,390, and he's actually paid over 6,150 on one case. And on the other case, he's paid 9,470 total.
Okay,
But he's consistently does.
that's not an
pay.
issue. How much, was there any restitution on any of those? There wasn't any restitution on
Not that
that?
I'm aware of.
Okay. All right. Right, what are you asking?
We're asking to be continued, Your Honor, to give an opportunity to complete the probation. Or if the court's not inclined to continue, then consider a sentence at the lower end of the sentencing range.
All right, anything else to add?
No, yeah.
If not, I'm going to find in each of these two cases, cause numbers 18-28788 and 29417, that in these motions to revoke probation, first of all, in 28788, the second degree felony of illegal possession of methamphetamine, a controlled substance for which the defendant was sentenced to 10 years in prison, and that was probated for 10 years, that the court finds that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greater, as allegation 2 has been proven true, as the defendant has failed to follow that requirement of performing community service hours as required, as the probation office states that the defendant has essentially failed to do any of that. And thus, that violation supports the motion to revoke probation in this case, and your probation is hereby revoked. In 18-29417, the defendant was placed on 10 years deferred or unadjudicated probation for the second-degree felony of aggravated assault with a deadly weapon. And he also pleaded true in that case for failing to provide and perform community service hours as required in violation of condition 15 of each of these probation orders in these cases. And again, in that case, essentially no community service hour had been performed over a period of almost 8 years. And thus, I find that a violation of his probation, and this motion to revoke unadjudicated probation in that case is hereby revoked by preponderance of the evidence or greater. In 28788, the court finds, based upon that probation being revoked for his failure to perform his probation requirements, as the court has placed into the record, your probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You'll be given credit for time you have served. In this clause number 18-29417, earlier you were placed on probation, deferred or unadjudicated probation, and now the court grants this motion to revoke unadjudicated probation, and your probation is hereby revoked. Earlier in this case, you pleaded guilty to the second-degree felony of aggravated assault with a deadly weapon. Voluntarily, knowingly, intelligently, there was sufficient evidence supporting your guilty plea at that time to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of that offense based upon the violation of probation. And you were hereby found guilty, and you were sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. These two sentences shall run concurrently. On this case, an affirmative finding is rendered in the judgment that a deadly weapon, namely a firearm, was used in the commission of that offense. And again, you are given credit for what we have here is over 600 days. Do you understand what has happened today, sir?
Yes, sir.
Yeah, it was irresponsible, and you have a family at home.
Absolutely.
You got to think of them, not whatever caused this mess first. They should always come forward first.
Absolutely.
For you. Not, when you make a decision, you got to think how much not only you lose, but the people who depend upon you. We're always third. We're always third. Creator is first. Others are second. You come in third. That's the way it should be.
Absolutely. I couldn't pay. And the community service is on.
Community service, you're not being punished for failing to pay. You did what you could. It's community service, though, is something that you have to show, which fixes this mess. It's a kind of a moral issue, showing that you can help repay, because you can't replace the threatening behavior that people were traumatized over. But community service is a form of kind of trying to fix that by helping the community be a better place. But you didn't do a dime over a period of 8 years. But let's face it, these two offenses, you had no business acting that way.